SHRM-CP and SHRM-SCP Prep Part 3 by Human Resource Prep. Have you subscribed to this channel? Please do. Would you like to see more videos like this for free? Then please subscribe and click on the like button. The charred organization simultaneously has both a universal outlook and a local identity in the countries it operates in. The CEO has said that charred will continue to be characterized by both local and global considerations, as this has proven to be an effective long-term strategy. Charred most likely practices globalization, a polycentric and geocentric model. Globalization, an ethnocentric and geocentric model. The answer is C. Globalization is the practice of conducting business according to both local and global considerations. Such organizations have a strong global image but an equally strong local identity, thereby reflecting both local and global considerations. The term refers to think globally, act locally as a business strategy for companies with a global presence. Is a type of retirement plan in which the employer, employee, or both make contributions to an individual account on a regular basis. Defined benefit plan, non-qualified plan, Scanlon plan, defined contribution plan. The answer is D. In a defined contribution plan, the employee and/or the employer contribute money to the employee's individual account in the plan. The employee is responsible for choosing how these contributions are invested, and decides how much to contribute from his/her paycheck through pre-tax deductions. At retirement, the employee receives the balance in his/her account, which is a reflection of the contributions, investment gains or losses, and any fees charged. 401k plan is a popular type of defined contribution plan. Is a type of tax-deferred, employer-sponsored retirement plan that falls outside of the Employee Retirement Income Security Act guidelines. Non-qualified plan, defined benefit plan, defined contribution plan, qualified plan. The answer is A. A non-qualified plan is a type of tax-deferred, employer-sponsored retirement plan that falls outside of the Employee Retirement Income Security Act, hrci, guidelines. A non-qualified plan is not required to meet most of the requirements that hrci or the Internal Revenue Code imposes on tax-favored qualified plans. These plans are designed to meet specialized retirement needs for key executives and those at the top of the corporate hierarchy. Examples include executive bonus plans, top hat plans, supplemental executive retirement plans, SERPs, etc. A qualified plan, on the other hand, provides IRS-approved tax advantages and must abide by hrci requirements. Examples include defined benefit plans and defined contribution plans. Jane's retirement plan is funded by the employer. She has been promised that she will receive a specific monthly dollar amount at retirement. Her pension benefit is calculated based on a formula where her benefit is equal to 3% of her average salary for the last 5 years of employment multiplied by her total years of service. Jane's plan is a Rabbi Trust, defined benefit plan, defined contribution plan, qualified plan. The answer is B. A defined benefit (DB) plan is a retirement plan that is funded by the employer, and promises the employee a specific monthly benefit at retirement. The plan may state this promised benefit as an exact dollar amount, such as $1,000 per month at retirement, or it may calculate the employee's benefit through a formula that includes factors such as salary, age, and the number of years worked at the company. In a defined benefit (DB) plan, the employee knows beforehand what the retirement benefit will be. In a defined contribution (DC) plan, the employee does not know the specific retirement benefit, but he or she knows what contributions are being made. In a DC plan, the employee's retirement benefit will be based on contributions and investment gains, losses. What does the Glass Ceiling Act state as the 3 barriers to minorities and women advancing in the workplace? Internal structural, societal, and governmental barriers. Lack of an affirmative action plan, gender bias, societal barriers. External structural, societal, performance barriers. Discriminatory, lack of an affirmative action plan, industrial barriers. The answer is A. The Glass Ceiling Act of 1991 is an amendment to Title II of the Civil Rights Act of 1991. The United States Federal Glass Ceiling Commission defines the glass ceiling as the unseen, yet unbreachable barrier that keeps minorities and women from rising to the upper rungs of the corporate ladder, regardless of their qualifications or achievements. The Commission identified 3 barriers, which are internal structural barriers, societal barriers, and governmental barriers. Per the National Labor Relations Act, the right to engage in concerted activities for the purpose of collective bargaining or other mutual aid or protection is not provided to those employed based on a piece rate form of compensation, those whose tasks involve corporate finance and accounts, those who are independent contractors, those who are temporary employees. The answer is C. Most employees in the private sector are covered by the NLRA. However, the Act specifically excludes individuals who are employed by federal, state, or local government, employed as agricultural laborers, employed in the domestic service of an or family in a home, employed by a parent or spouse, employed as an independent contractor, employed as a supervisor. Supervisors who have been discriminated against for refusing to violate the NLRA may be covered. Employed by an employer subject to the Railway Labor Act, such as railroads and airlines. Employed by any other person who is not an employer as defined in the NLRA. What can an employer do when employees begin to unionize? The employer can publicly share facts from reputable sources about the union's past corrupt practices. The employer can share real-life examples and stories to highlight why a union might not be the right choice. The employer can highlight that employees will have to pay union dues if a union is elected. All of the above. The answer is D. During a union campaign, employers are permitted to engage in activities that will not interfere with an employee's ability to make a free and fair choice in a union election. Employers cannot threaten, interrogate, promise, spy, tips, on employees. However, the employer can share facts, opinions, and examples that are true and do not violate tips. Occurs when a union requires that an otherwise obsolete job remain at an organization in order to avoid terminating an employee. Comparable worth. Escalator clause. Feather bedding. Grandfather clause. The answer is C. Feather bedding is an unfair labor practice, ULP, where the union seeks to deliberately limit production or retain excess staff in an organization in order to create jobs or prevent unemployment, based on a union contract. It is also called make work. Comparable worth is the evaluation of jobs traditionally performed by women or minorities to establish whether or not the worth of those jobs to the employer is comparable to the worth of the jobs traditionally performed by white men, and the payment of extra wages to women and minorities occupying comparable jobs but receiving less income. Escalator clause refers to a union contract provision for the raising and lowering of wages according to changes in the cost of living index or a similar standard such as a cost of living adjustment, COLA. Grandfather clause is a union contract provision specifying that employees on the payroll before a specified time will retain certain rights and benefits even though newer employees are not entitled to these rights. The Drug-Free Workplace Act of 1988 applies to what kind of organization? Choose all that apply. Private organizations receiving federal grants. Organizations with federal contracts of at least. The answers are A and B. The Drug-Free Workplace Act of 1988 applies to any organization receiving a federal grant of any size, and any organization that receives a federal contract of $100,000 or more. The Act requires that such organizations prepare and distribute a formal drug-free workplace policy statement, and establish a drug-free awareness program. Ensure that all employees working on the federal contract understand their personal reporting obligations. An employee must notify the employer within 5 calendar days if he or she is convicted of a criminal drug violation. Notify the federal contracting agency of any covered violation. The employer has 10 days to report that a covered employee has been convicted of criminal drug violation. Take direct action against an employee convicted of a workplace drug violation. This action may involve imposing a penalty or requiring the offender to participate in a rehabilitation program. Maintain an ongoing good faith effort to meet all the requirements of the Act throughout the life of the contract. Kathy works in HR and has received a request from a job applicant who states he is disabled. What is Kathy's responsibility with regard to compliance with ADA? A. Kathy must provide the reasonable accommodation requests of the disabled applicant. B. The ADA imposes affirmative action requirements on the recruitment process at Kathy's organization. C. Kathy must engage the disabled applicant in an interactive process to discuss the possibility of a reasonable accommodation. D. Kathy is required to provide employment for the applicant with a disability only if he can perform the essential functions of the job with a reasonable accommodation. The answer is C. The Americans with Disabilities Act requires that employers engage in an interactive process on reasonable accommodation requests with applicants, employees with disabilities. There is no requirement to implement a request if it creates an undue hardship. An individual with a disability must be qualified to perform the essential functions of the job with or without reasonable accommodation, in order to be protected by the ADA. The ADA does not interfere with the right to hire the best qualified applicant, nor does the ADA impose any affirmative action obligations. The ADA makes it unlawful to ask an applicant whether she is disabled or about the nature or severity of a disability, or to require the applicant to take a medical examination before making a job offer. Note that pre-employment drug screens for illegal drugs do not constitute medical examinations under the ADA. Which of the following is not one of the steps in the enterprise risk management process? Risk identification, employee risk assessment and culpability, risk management activities, risk-based monitoring. The answer is B. Enterprise risk management, ERM, involves the methods and processes used by all organizations to manage risks and seize opportunities that enable the organization to achieve its objectives. ERM is focused primarily on identifying, monitoring, and managing organizational risk to ensure such risks do not interfere with an organization's objectives and operations. It does not focus on employee risk assessment or identifying employees who are responsible for risks. Note that ERM focuses on organization-level risks and not necessarily business unit-level or employee risk assessments. The steps in ERM include risk identification, policy development, risk management activities, risk-based monitoring, etc. What did the Herzberg motivation and hygiene theory establish? There are factors that cause job satisfaction while a separate set of factors cause dissatisfaction, all of which act independently of each other. An employee makes an association between a particular behavior and a consequence. Employee psychological health is predicated on fulfilling innate human needs in priority, culminating in self-actualization. employees who perceive themselves as either under-rewarded or over-rewarded will experience distress, and that this distress leads to efforts to restore equity within the relationship. The answer is A. The Herzberg two-factor motivation hygiene theory states that there are factors in the workplace that cause job satisfaction while a separate set of factors cause dissatisfaction, all of which act independently of each other. It concludes that there is no real correlation between job satisfaction and job dissatisfaction, and both terms are not opposites. Motivators such as achievement, recognition, responsibility, advancement, and growth give employees the opportunity to excel and will bring overall success to the entire company. Hygiene factors include salary, security, supervision, work conditions, etc. Improving motivators will increase job satisfaction. Improving hygiene factors will decrease job dissatisfaction. According to the Genetic Information Non-Discrimination Act, an employer is legally culpable if genetic information is obtained inadvertently. Employers who self-insure coverage can use genetic information to screen out employees for health benefits under the Safe Harbor rule. An employer may use genetic information to make an employment decision if it is relevant to an individual's current ability to work. It is not illegal if an employer obtains genetic information accidentally or pursuant to the FMLA. The answer is D. Genetic Information Non-Discrimination Act of 2008, GINA, prohibits the use of genetic information in making employment decisions. An employer may not use genetic information to make an employment decision because genetic information is not relevant to an individual's current ability to work. It is also unlawful for employers to request, require, or purchase an applicant's or employee's genetic information. There are a few exceptions to this rule, such as, when an employer gets genetic information inadvertently or pursuant to the FMLA, when an employee receives voluntary health or genetic services that an employer offers, or when an employer acquires genetic information from sources that are commercially and publicly available, like newspapers, books, and public websites. An employer must keep any genetic information it does acquire about an applicant or employee confidential. The Trade Adjustment Assistance Program was established to petition against offshoring and its antecedent effect of significant job loss to other countries. Supplement unemployment insurance benefits paid by the states. Provide aid to workers who lose their jobs as a result of increased imports. Retrain blue-collar employees to ensure their skills are relevant for the 21st century. The answer is C. The Trade Adjustment Assistance (TAA) program is a federal program established under the Trade Adjustment Assistance Reauthorization Act of 2015 that provides aid to workers who lose their jobs or whose hours of work and wages are reduced as a result of increased imports. The TAA program offers a variety of benefits and re-employment services to help unemployed workers prepare for and obtain suitable employment. Workers may be eligible for training, job search and relocation allowances, income support, and other re-employment services. A petition for TAA may be filed by a group of 3 or more workers, their union, or other duly authorized representative. The Think Corporation has switched its compensation philosophy from performance to entitlement. This is based on metrics that indicate a bulk of the employees have steady progressive performance levels. An entitlement philosophy will most likely reward based on longevity, reward based on skills and engagement levels, reward based on a flat structure, reward based on broad banding. The answer is A. An entitlement compensation philosophy rewards employees based on longevity at the company. This philosophy assumes that employees who have worked another year are entitled to pay increases, with little regard for performance variables. Pay and promotion decisions are based on length of service with the company. A performance compensation philosophy, on the other hand, compensates employees for the level of performance that each individual employee achieved. Pay increases are given to employees who perform satisfactorily or above satisfactory, and the rate that compensation increases is variable per employee. The Employee Polygraph Protection Act permits polygraph tests to be administered to job applicants of security service firms. Permits polygraph tests to be administered to job applicants of pharmaceutical manufacturers. Permits polygraph tests to be administered to employees involved in a workplace incident that resulted in specific economic loss or injury to the employer. Permits all of the above. The answer is D. The Employee Polygraph Protection Act, EPPA, prohibits most private employers from using polygraph lie detector tests, before or during the course of employment. Subject to restrictions, the Act permits polygraph tests to be administered to certain job applicants of security service firms, armored car, alarm, and guard, and of pharmaceutical manufacturers, distributors and dispensers. Also subject to restrictions, the Act permits polygraph testing of certain employees of private firms who are reasonably suspected of involvement in a workplace incident, theft, embezzlement, etc., that resulted in specific economic loss or injury to the employer. The EPA is administered and enforced by the Wage and Hour Division, WHD. The EPA applies to most private employers but does not cover federal, state, and local government agencies. Which of the following is true with regard to workers' compensation? The employer is only responsible for providing workers' compensation for work-related injuries that were due to the employer's negligence. The employer is responsible for providing workers' compensation for all forms of injury that employees may sustain. The employer is responsible for providing workers' compensation for work-related injuries that employees sustain. The employer is not responsible for providing workers' compensation for work-related injuries that were due to the employee's negligence. The answer is C. Workers' compensation is a state-mandated insurance program that provides benefits to employees who suffer work-related injuries and illnesses. Generally, an employee with a work-related illness or injury can get workers' compensation benefits regardless of who was at fault, the employee, the employer, or a third party. Workers' compensation laws state that employers are responsible for any work-related injuries or problems that employees sustain on the job. Which of the following was established by the Personal Responsibility and Work Opportunity Reconciliation Act? Employers and employees are subject to the common law doctrine of employment at will. New hires must be reported to the state within 20 days of the date of hire. An employer is liable for the actions of its employees performed within the course of their employment. Employers must verify the employment authorization of new hires. The answer is B. The Personal Responsibility and Work Opportunity Reconciliation Act, PHRi, made employers subject to reporting and retaining of employee identification records, and established a welfare reform plan that requires work in exchange for time-limited assistance. The PHRi requires that employers report all new hires to state agencies within 20 days of the date of hire for transmittal of new hire information to the National Directory of New Hires. Respondite superior is a doctrine that a party is responsible for acts of their agents. In the United States, there are circumstances when an employer is liable for acts of employees performed within the course of their employment. Form I-9, Employment Eligibility Verification, requirements came out of the Immigration Reform and Control Act of 1986, IRCA. The Form I-9 is used for verifying the identity and employment authorization of individuals hired for employment in the United States. A disadvantage of e-learning is higher withdrawal rates than traditional forms of learning, restrictive attendance requirements, convenient and self-paced, face-to-face interaction with peers and instructor. The answer is A. E-learning is learning conducted via electronic media, typically on the Internet. Advantages of this form of learning is that it is self-paced, convenient, with little or no restrictive requirements. However, a key disadvantage of e-learning is a higher withdrawal, dropout rate than other forms of learning. Trainees may switch off from fully engaging in the material, and eventually drop out altogether. The federal government of Germany has charged the employees of a business headquartered in Germany with an allegation that they paid bribes to custom officials in Peru. What legal principle does this illustrate? Jurisprudence. Extraterritoriality. Forum shopping. International rule of law. The answer is B. An extraterritorial application of a statute involves the regulation of conduct beyond the home country's borders. Extraterritoriality comes into play when the law endeavors to regulate conduct of persons with respect to place of occurrence of the event subjected to the regulation. Extraterritorial laws can be applied by a country to businesses owned in that country and to their employees, even when the actions in question occurred in another country. Jurisprudence is the theoretical study of law. Rule of law refers to the restriction of the arbitrary exercise of power by subordinating it to defined and established laws. Forum shopping occurs when multiple courts have concurrent jurisdiction over a plaintiff's claims, and the plaintiff chooses the court that will treat his or her claims most favorably. What is the objective of sensing meetings in the organizational effectiveness and development process? A. Sustaining a change initiative. B. Needs assessment for a change initiative. C. Team collaboration towards the establishment of a change initiative. D. Strategic development of a change initiative. The answer is A. The organizational effectiveness and development (OAD) process is the process of improving the effectiveness and efficiency of an organization and the well-being of its members through planned interventions. Sensing meetings monitor reactions and attitudes to a node initiative after it has been applied. These meetings are opportunities to determine group reactions to an initiative after it has been implemented. These meetings help provide early indications of additional steps that may be required post-implementation of the initiative. The Think organization has begun its budget planning process. The CEO has determined that due to falling sales figures and the pullout of two key investors, every function is required to cut its budget by 5%. This budgeting method refers to A. Incremental budgeting. B. Historical budgeting. C. Formula budgeting. D. Zero-based budgeting. The answer is D. Formula budgeting is the use of predetermined mathematical formulas to determine the estimate of income and expenditure for a set period of time. This method applies an average cost to income or expenses, and funds are increased or decreased by a specific formula. Zero-based budgeting is a method where the current year's budget is prepared from the scratch without considering past budgets. Incremental budgeting is a method where the current year's budget is prepared by making changes in the past year's budget. The changes may be an addition or reduction of expenses to last year's budget. Note that the question makes no mention of the company's budget for the previous year. According to Nancy Adler, which of the following terms describe a challenge to cross-cultural communication that absolves individual responsibility by ascribing obstacles to inherent cultural resistance? A. Ethnocentrism. B. Cultural determinism. C. Cultural relativism. D. Parochialism. The answer is B. Cultural determinism is a term used to describe the concept that culture determines economic and political arrangements. It is a perspective that places responsibility for actions or inactions on local cultural factors while individuals are absolved of responsibility for their actions. Ethnocentrism describes the act of judging another culture and believing that the values and standards of one's own culture are superior. Cultural relativism is the idea that a person's beliefs, values, and practices should be understood based on that person's own culture, rather than be judged against the criteria of another. Parochialism is a term used to describe a narrow focus on small sections of an issue rather than considering its wider context. What are the three spheres of sustainability? Water, air, earth. Ecological, corporate, community. Global, regional, communal. Social, environmental, economic. The answer is D. Sustainability is defined as meeting the needs of the present generation without compromising the ability of future generations to meet theirs. The three spheres of sustainability are economic, environmental, and social. These three spheres are also referred to as the 3 Ps: people, planet, and profits. Did you find this video helpful? Would you like to see more videos such as this for free? Please subscribe and click on the like button.